Good morning, good morning, good morning again, folks. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels, and we are going back to that horrible world known as the JRC. But before we do the disclaimers, this is going to be the new shortened version. So, folks, if you are brand new in regards to the situation in regards to the Judge Rotenberg Center or Agape, Tobin World, all these different schools, you're going to find all the pertinent links in regards to these situations found right there in the description box. Also noted in the description box, the threat of the JRC in regards to NeuroClastic, a small non-for-profit that is for autistics and started by autistics, as well as their public statement. If you're new to all of these subjects, please, all the links are in the description box. Please pull them up and take a look at them, okay? Warning, when we discuss places like Agape, like the JRC, you're going to see video clips of and surveillance footage of peoples with disabilities and mental health issues being abused. If you got young children present, please use the headphones, all right? Also, this channel is marked not for kids for a reason. We use profanity on occasion and we speak on dark subjects. If your child is 16 and younger and they're watching this, very obviously, parental supervision is advised. Face it to say, if you want to know what in the world that we're talking about, use those links, okay? All right. Where we left off. I feel better now. On the last theory of constitutional protection against the use of at least some adversives that it violates students' rights under the Fourth Amendment, which protects against unreasonable searches and seizures. Specifically, the New York Court of Appeals in Peters versus Rome City School District found that the use of restraint and seclusion on a student with disabilities on 75 different occasions, 75, damn, within one school year constituted a seizure, or rather a series thereof, for the purposes of the 14th Amendment. It went on to say that the jury of the court below had properly reached the conclusion that these seizures have been unreasonable and thus a constitutionally imperishable. Now, let me tell you about double standards, folks. This is where people like me, our rights don't seem to count when we're talking about public schools, okay? These individuals will use every excuse under the sun to invade our privacy. Remember that places like the JRC will use arguments and stereotypical tropes. This is why representation actually matters, folks. To be able to have someone literally sit on the toilet with the person with a disability in the shower. Okay? Yeah. Yeah. A lot of reasons you won't see these cases come to light is, remember the types of students in our families that these folks prey upon. They're not going after the rich kids, folks. They're going after the kids who come from poor families who don't have the means to fight this. It's the very rare occasion when they manage to go after the wrong student that literally any of this stuff comes to light at all. At all. The fact that we are starting to see it more in the news, in spite of the person's background and where they come from, has everything to do with the fact that everybody has camera phones now. Okay? Just saying. Few cases would likely rise to this level of excessiveness, and not all aversives would count as seizures for the purposes of the Fourth Amendment. However, the reasonable inquiry involved in such a case would leave somewhat less discretion through the professional judgment standard that comes up in addressing the 14th Amendment questions. Obviously, search and seizure is a very different animal than the aversives they get up to using. It's even harder to establish a liability of a private school or facility for federal constitutional violations than it generally is to do so in a public school setting. This is because 42 USC 1983, the federal civil rights statute under which the student can sue a school or program for violation of a constitutional right, requires him or her to show that the program was acting under the color of state law, which is obviously the case with public schools, but much less so with private ones. If you've been following the situation with Agape and the tumbled teen industry, this should be very glaringly obvious to you. You have private schools that can literally get away with not being state or federally accredited, still being able to take in students, okay? Yeah. Yeah. Private schools get away with a lot. A lot, folks. Because there's no real checks and balances in place that can be used in situations like the JRC, like Agape. Yeah, you see where I'm going with here, right? They can get away with a lot more than public schools can, because there's no checks and balances for them that are there for the public school sector, because they are privately funded and not state or federal funded. At least on paper, they're almost a world in and of themselves. This is, again, why we need new laws. This is why almost we need our private school sector department there, why there should be guidelines there for the private schools. Because otherwise, what you're essentially telling us, those of us who get sent to these places, is that in actuality, we have no protection because it's privately funded. Okay? Let's move on, shall we? In order to do this, a plaintiff must prove either that the defendant private entity performs a traditional state function, or that there was a close nexus between the state and a private entity with regards to conduct at issue in the case. Courts have set a high bar for plaintiffs to meet in establishing this either. This extends to cases involving private schools, treatment programs, and combinations thereof. There's no federal guidelines, folks. Let's put it blunt, okay? For places like the JRC out there, for places like the Agape, for places like Circle of Hope and Turban World, there is no set in stone guidelines that places like this have to follow. If it sounds scary, it's because it should be. Because these folks do not have to jump through all the hoops that the public school has to. There's not the same level of checks and balances as there are with a public school. This is how places like the JRC continue to get away with it year after year after year. This is why, though, JRC, unlike a lot of the troubled teen industry, can, however, be caught with their hands in the cookie jar, so to speak, because they have received federal and state school district funding for individual students who get sent there by their schools and not their parents. Which means when they are not meeting that federal criteria in a perfect world, that funding can be removed. Technically. But yeah, we live in a greedy world, folks. And the JRC is known for their proclivity of greasing palms to continue their insanity. This extends to cases involving private schools, treatment programs, and combos thereof. First of all, neither private alternative education nor inpatient mental health treatment is considered a traditional state function for the purpose of establishing state action. Furthermore, courts have held that even significant state funding and regulation of a program by itself is insufficient to establish sufficiently close nexus between state and a program or school. See that there, right? So the so-called protections that places like JRC like to throw around aren't really protections at all. That is the point here. Okay? States do not like to step in situations in places like the JRC when it's a combo of medical care as well as education. Because again, we live in a society that accepts whatever the professionals say without question, even when we should. Okay? If you want to take a look at some of the individuals who believe what the professionals say without a question, take no look further than our own federal Congress and Senate. They don't want to step their foots in it because they don't feel like, well, we have no right to legislate medical care. This is what the parents want. Everyone's afraid of their own shadow, folks. My stepmom used to have the saying, your rights in when they trample on mine. You know what I'm saying? You are blindly believing the professionals and leaving it to them to the point that it is violating the students' human rights. Okay? You are so scared to get involved because it's involving both education and medical care that you are talking yourself out of defending the most vulnerable in our society. We got to stop ignoring red flags in the name of doctorate degrees. Okay? We got to stop blindly believing everything these so called professionals spew out. Because, as I pointed out in a previous video, not all medical professionals are created equal. Okay? We're going to close out on that. We don't get very many views on this channel. The few that we do get do tend to get removed from time to time. Please don't forget to hit the like button, hit subscribe, and don't forget to hit the comments. I do appreciate your time. And as always, folks, we here at Spilling Tea hope you have a good one. I will see you next vid. Bye-bye.